I wanted to talk about whether or not California should codify additional interpretive directives to the courts. The more I delve into statutory interpretation and construction, the more I'm confronted from a legislative drafting perspective whether some codified interpretive guidance should be provided to the courts in our state by placing these other directives in statutes. As you may be aware, California courts already use a number of judicial principles when interpreting ambiguous statutes. Of course, as a general rule, our courts rely upon the plain or ordinary meaning of statutory language. However, where there is ambiguity, then the judiciary turns to the goal of determining what is the intent of the legislature. As a result, that raises with me whether the legislature should codify this goal and perhaps a number of others for the courts to follow when they're interpreting an ambiguous statute, such as when statutory language is susceptible to two or more reasonable interpretations. In other words, should California put in statute the goal of effectuating legislative intent and also putting in statute some other directives for state judges and justices to follow? For example, I came across in the Minnesota statutes a similar provision. It says that the object of all interpretation and construction of laws is to ascertain and effectuate the intention of the legislature. So it'd be easy for California to adopt a similar statute and add this as a section to each of the 29 codes. In case readers are not aware, California statutes already provide a number of interpretive guidelines in statute. For example, in almost all of the 29 California codes, there are general or preliminary provisions, they say, or call them, that provide guiding principles to the judicial branch of state government. For example, Government Code Section 9603 specifies that the general rules for the construction of statutes are contained in the preliminary provisions of the different codes. For example, the codes all contain a section that specifies the word shall is mandatory and the word may is permissive. Now, of course, the notion of codifying statutory interpretation principles into state law does raise a fundamental question of whether the judiciary should or has to consider these indicia of legislative intent. Generally, legislative history and intent has long been a hotly debated topic in judicial and academic circles when it comes to the concept of statutory interpretation, particularly featured at the federal level, primarily among Supreme Court justices, in fact. But my suggested approach would attempt to address the debate head on by having the legislative branch of state government provide the judicial branch of state government with some specified guidance on how to proceed with statutory interpretation. Yes, of course, it's understood that the judiciary would not be bound by these legislative pronouncements as they aren't today. They can ignore codified principles of interpretation. Now, why is that? Because while the legislative branch is charged with the lawmaking authority, the judicial branch is in the state at the federal government as well, naturally charged with interpreting the laws. And judges and justices get to use, among other things, canons of statutory interpretation, which, of course, is the common law or judge-made law. Um, in doing so, in other words, using these canons of statutory interpretation or these principles of statutory construction. There's another school of thought, however, that the judicial branch is bound by all statutes and would be as well by statutes that direct how legislative enactments should be interpreted. For example, a provision found in several hundred state laws today, just here in California, is for a particular statute to be quote unquote liberally construed to effectuate its purposes. Now, if that statutory provision binds the judiciary, then why wouldn't a statute that mandates, for example, judicial use of legislative history materials also be binding on the courts? California's judiciary always begins their interpretation of a statute by considering its plain or ordinary meaning. The judicial branch turns to other interpretational aids, so-called extrinsic aids, when it finds ambiguity in the statute. California could, even if it wanted to, codify that principle. In fact, some states have codified the plain meaning rule, which California could do as well. Some states have also codified that legislative history should be used to construe an ambiguous statute in order to ascertain the intent or effectuate the intent of the legislature. This is also another interpretation directive that California could easily enact. In some states, again, Minnesota is an example I was looking at, a statute directs the courts to look to the contemporaneous legislative history, which can include statements by legislators in debate. One state uses the following language. In considering the text of a statute or rule, the following aids to construction may be considered in ascertaining the meaning of the text. One, the meaning of a word or phrase may be limited by the series of words or phrases of which it is a part. And two, the meaning of a general word or phrase following two or more specific words or phrases may be limited to the category established by those specific words or phrases. As some other examples, more than 30 states today codify two key statutory interpretation principles. One, ordinary usage, which they generally define as following the so-called ordinary use of those terms, unless the legislature gives those terms a specified or technical meaning. And then dictionary definition, which generally means to follow the dictionary definitions of terms unless the legislature has provided a specific definition. What are some other interpretive directives that could be codified in California statute? The following I would recommend: the plain meaning rule, ascertaining or effectuating legislative intent, reviewing legislative history. In other words, reviewing legislative history such as bill analyses and author statements to understand the purpose. The whole act rule, meaning interpreting specific sections in light of the entire statute. Again, while perhaps not binding on the courts, these codified interpretive guidelines could carry and should carry weight with the courts in California. Then our state courts could be informed of what the legislature desires when interpreting their language, the text that they have developed for the statute. While the courts, again, will have final word on interpretation and what a statute means, these directives would be a matter of state law and would clearly establish the legislature's goal considering how to interpret California statutes.